We are joined tonight for our States' Rights versus Federal Power webinar by two powerful people. We have Katie Crawford Lackey, who is the director of the Robert H. Smith Center for the Constitution at James Madison's Montpelier. Trained as a public historian, she specializes in museum management, historic site interpretation, historic preservation, and digital storytelling. She received a PhD in public history at Middle Tennessee State University. Welcome, Katie. Then we will hear from Jim Blumstein, ranks among the nation's most prominent and influential scholars of health law, law and medicine, and voting rights. At Vanderbilt University, he is the University Distinguished Professor of Constitutional Law and Health Law and Policy, Professor of Medicine and Director, and the Vanderbilt Health Policy Center. Welcome to you both. And Katie, we're going to begin with you, please.
Great. Well, it's a pleasure to be talking with you all tonight. I did graduate from Middle Tennessee State University and I lived in Tennessee. I'm in Virginia now, so I can't claim to have Tennessee residency anymore, but it's great to be back with this group. I'm going to go ahead and share my screen. Hopefully you can see a PowerPoint up there. So as Marilyn mentioned, I'm the Chief Project Officer at James Madison's Montpelier. I joined the organization in 2021 as the public historian, then later served as director of the Center for the Constitution up until a few months ago. And so for context, Montpelier is located in Central Virginia. It's the plantation home of James Madison, and he's known as the father of the Constitution, architect of the Bill of Rights. He also served as fourth president of the United States. So I'm really looking forward to speaking with you all about this topic of states' rights versus federal power, which is really a key focus of Madison's political life. And it's a topic that's very relevant today. It continues to spark conversation and is really at the core of many legal, political, civic debates. And Madison is an important figure when we talk about this topic, not because he was the only political mind concerned about striking a balance between state and federal power, but because, in contrast to some of his contemporaries, he was really engaged with this question for decades and decades, and in a number of different capacities or roles. So over the next 10-15 minutes, I'm just going to be talking about this concept of balancing state and federal power, because it's kind of the foundation of our government system. And so on the screen here, you'll see there's Montpelier, the mansion where Madison lived, and there's a bust of Madison himself. And then there's this beautiful view that Madison had from his upstairs study, where he's drafting the Virginia plan, taking it to the Constitutional Convention. So that's his view of the Blue Ridge Mountains. Now, before I go any further, I want to define what this means in terms of state versus federal power. So, we're talking about a structure or framework of government and the way it's implemented in America. Referred to as federalism, it's this system where power is divided and shared between two different levels. So we've got the national level, or federal, and then we have the state level. So state governments, this more regional located, obviously. Now, when Madison and his contemporaries are crafting the Constitution, they are looking to divide power in a way that allows for individual freedoms, but they're very concerned about tyranny. They just broke away from the monarchy. Madison is also very concerned about majority tyranny. So they're trying to create this functional government, creating this balance. And it's never been done on such a large scale before. And that's what, in part, makes our Constitution really unique. I also want to note that while this is, we're talking about federalism, this framework for our government, it also involves this question of, who gets to make these decisions about what happens in the country, in your state. It's about, who we are, our identities. It's about what we value and who we trust. So oftentimes when we talk about this issue, it can become very personal. for those reasons. And while this structure is set up in the Constitution, it's one that lives beyond the ratification of the Constitution. And while federalism as a framework is still part of our Constitution, it still endures, how it's interpreted and applied and how this balance, it really shifts over time. And this is, I had to include this. This is James Madison's Montpelier from kind of an aerial view. You can see the mansion off in the corner there circled. But this gives you a sense of, where James Madison is thinking about these really critical topics as he's drafting the Virginia Plan. So I want to kind of go back a little bit because obviously the Constitution is a really important part of, how the framers decided, this division of power. But it really goes back further to the colonial era. This question of who has ultimate authority, who has the right to govern, that becomes a galvanizing factor in the colonies declaring independence from Britain. So just kind of a brief overview of how these colonial governments are structured before the Declaration of Independence. There is this authority is to the monarch. So the Crown of Britain, that's the ultimate authority. But there's not one kind of unifying governing body that's overseeing the 13 colonies as a collective. Instead, each colony has a governor, usually appointed by the monarch in the case of royal colonies. There's also a legislature, and then at the local level, there's town councils, groups more locally that are making laws or decisions. And I don't want to get too in the weeds with this, but I wanted to give you a sense of how it's structured, because while colonists do have some autonomy, again, mostly in their local communities to make laws, policies, at the end of the day, the crown, the monarch, or the royal governor can kind of veto or tell these legislatures, no, we're going to overturn this law. So ultimate authority still rests with the governor and the crown. And over time, we see Britain trying to assert more control in the colonies, especially after the French and Indian War. This is a war that's very expensive for Britain. They start levying taxes on the colonies, and colonists are just feeling like their voices aren't being heard, they're not being represented. They feel like it's a violation of their rights. And we see this tension evolve, particularly in the 1760s and 1770s. We see, again, the increase in taxes, and then we see the colonies pushing back through various protests. And James Madison, at this point in time, he's born in 1751. And so he's, gone off to college at this point. He's a young man. And he's at the College of New Jersey, which is Princeton. And so he's kind of experiencing and hearing about all these various things happening amongst the different colonies, the way that colonists are pushing back, issues they have with the crown. And he's having this, education by this Scottish Presbyterian Enlightenment thinker. And he's beginning to think about, why do we invest authority in the crown? Why should that be the ultimate authority that makes these decisions? So this is kind of the backdrop for a young Madison. And as the colonies begin contemplating breaking away from the crown, they are essentially going to lose that structure we talked about. So what they've been, used to with this colonial government, there's no national government that comes in and replaces the monarchy. So the colonies begin to draft their own state constitutions. So each colony is going to vote to break away, and then they draft their constitutions. And Madison is involved with the drafting of the Virginia Constitution in 1776. Now, as they break away, declare independence, there is not like a unifying national government. Instead, these newly established states are essentially brought together by a shared goal, and that is to defeat the British. So they kind of have a quasi government during that time that's mostly run by the Second Continental Congress. So that governing body doesn't really have the authority to make decisions or tell these states what to do, but it's kind of providing direction during this period up until the Articles of Confederation are adopted in 1781. And in 1781, the war is still going on. And then particularly after the war, 1783, this newly freed nation, which is essentially just amalgamation of states, are being kind of governed by the Articles. And it's very clear early on that it's not working. It sets up a very weak national government. So the states are very strong. They're essentially acting as their own countries. And the reason for this, the reason why the Articles of Confederation are set up this way, is because there's a deep fear of tyranny breaking out again. So, they just fought this battle against the British, trying to assert their independence. They don't want to go back to that again. So instead, they lean more heavily on states having most of the power. Now, under the Articles, there is a Congress, but there's no executive branch, so there's no one to enforce the law, no national judicial branch, so, no body to help kind of settle disputes. Also, there's other major issues. The national government cannot tax the states. They can request that states pay taxes, but that's not very successful. They also cannot regulate trade, and the states, each individual state could declare war on another country. So it's at that point, America is in a very precarious position in the 1780s. And Madison is part of Congress at the time. So he is in his, about 32 at the time, in 1783. And here's a picture of him in 1783. So he's still a very young man, still fairly new to his political career. But he is seeing the flaws, and he is very concerned and thinks that this American experiment is in peril if something isn't done. So there's a growing consensus among the states that, we need to get together, we need to figure something out, we need to improve the Articles of Confederation. Well, Madison doesn't think that there is anything redeemable about the Articles. He personally wants to scrap it, but he doesn't necessarily suggest this outright. So the states try to come together in 1786 in Annapolis to try to, work out the problems with the Articles. Well, only 5 states show up. So they're not going to be able to accomplish much. So the states then decide, all right, we're going to get together next year, 1787 in Philadelphia, and we'll work this out. Well, Madison is going to be prepared. So he's going to spend 1786 and early 1787 at Montpelier in the upstairs library. And he is going to try to figure out a way to create a government that's actually going to work and create this balance that they've been talking about. And lucky for him, his good friend Thomas Jefferson is in France at the time. He sends Madison, tons of books, and Madison is reading, these ancient, philosophers, and he's reading Montesquieu, Locke, Hume. So it's not all originating from Madison, but he's reading about ancient confederacies and republics. He's figuring out where they went wrong and how he can replicate it, fix those problems, and put it into practice in a government for the United States. And then being informed by these ideas by Montesquieu, for example, separation of powers, John Locke with this social contract, limited government, David Hume, who's all about, checks and balances. So all this is going on in his head. On the PowerPoint, you'll see here's some of the books from his collection. Towards the end of his life, he had about 4,000 books. And his study in the upstairs library at Montpelier was just packed with papers, books, writings. And here's another great photo of the desk he was sitting at as he was looking out at this beautiful view. So as he prepares to go to the Constitutional Convention in the summer of 1787, he is really concerned that there's a balance of power, there's multiple layers of representation. He's seeing that, the Articles of Confederation gave the states too much power, but before that, the monarchy, there was too much central power. So how does he kind of come to this, realization? How do you divide power in a way that is protecting liberty and order? So creating this independent country, but also recognizing the autonomy of the states, because at this point they're used to being kind of their own independent countries in a sense. So he brings this Virginia plan that he prepares in this upstairs study to the Constitutional Convention. And as they go through this process of drafting a constitution, they're going to lay out what powers belong to the federal government and what belongs to the state governments. And this kind of dual federalism, so with the federal government handling things like national defense, currency, regulating interstate trades or other matters. And then states are going to control more of the local or regional aspects, things that are kind of unique to each locality. So education, for example, policing, today driver's license, that's done through your state. And one thing too I want to note as well, the idea of enumerated powers. When we talk about the Constitution and dividing this power up. And enumerated powers just refers to how the federal government is kind of given specifically these powers. So it's written out in the Constitution, particularly in Article 1, Section 8, which is essentially establishing the Congress, the legislative branch, and then what that branch can do. So what authority the federal government has. Again, we talk about, currency, interstate, regulation, commerce, all of that. And here's a better picture of this study where Madison's thinking about all of these ideas. At the time Madison is preparing for the Constitutional Convention, he is not quite this old. He is about 36. But this gives you a good sense of like that space and everything that happened there, all the studying and all the research that went into essentially creating a structure of government on a scale that had never been accomplished before. And so I won't go into all this because I know we have limited time, but this is kind of the foundation for how federalism starts from the early context. And then as it evolves over the centuries, it becomes really tied up in a lot of these, again, aspects of identity and what we value and, how this should be implemented, whether it's on a state or a federal scale. And so I'm eager to hear from my co-presenter, who I'm sure will have additional insights to share.
There we go. Thank you so much, Katie. So we're now going to be hearing from James Bloomstein, who's from Vanderbilt and who's going to enlighten us, not just from a Tennessee perspective, but just he's located in Tennessee. So looking forward to hearing from you. Take it away.
Thank you, Marilyn, and thank you, Katie, for a great introduction and explanation. We're going to cover some of the same, but I think my focus as a constitutional lawyer is going to be a little bit more nitty-gritty, but it was a great introduction. So I want to make these basic points. The Constitution was founded on the states, and at the risk of being a little too cute, we are the United States of America, and so the states are the foundation, and the unity among the states is critical. There are important values of federalism, of state autonomy, that I'm going to talk about. And also we found, and Katie mentioned this about risks, there are risks of federalism as well. So there are important values of federalism, and then there are some drawbacks too. And the concern about political, religious, racial minorities, what Madison called factions, and that Katie alluded to. I will describe the original structure of the Constitution and then demonstrate how, over time, state autonomy has been limited. That's the story I'm going to tell, is that over the last period since the Civil War, especially, and the New Deal, that the federal power has been expanded and state power, as a matter of law, has been limited, although not eliminated. And I'm going to describe those. The major players I'm going to talk about are the post-Civil War amendment, the 14th Amendment, and then the expansion since the New Deal of the Commerce Clause, and then ultimately of, since the New Deal as well, the growth of federal spending authority with great taxation ability and spending and use of conditions on spending. That has been a great source of federal authority to induce states with money if they play ball with federal values. And I think some would argue that really the spending power was even really more important in some ways than Brown v. Board, the legal case, in desegregating the South, because it turned out with the threat of cutting off federal funds that racial bigots were more concerned about green money than black or white. And it really was a way that the federal government could incentivize the states to desegregate. And then I will conclude by asking what is left of states' powers. And I'm going to talk about some of the structure that remains, and there is some, but much less than there was. Political culture of federalism becomes very important rather than legal focus. And then I'm going to talk a little bit about these restrictions in the context of the Commerce Clause and spending power. So that's in very broad brush what I'm going to be taking you through. I want to start with the discussion of federalism. Katie mentioned this, but I want to talk a little bit about it because I view this concern about local autonomy, state and local autonomy, as one of the most important issues of the last 25 years worldwide. And if you think about the breakup of the Soviet Union 30 years ago or so, 35 years ago, what we've seen is lots of emphasis on what used to be the Soviet Socialist Republics. We see now Ukraine separating out as a country, and Russia now trying to take more control than it had. Yugoslavia is another example where Yugoslavia was a country made up of different ethnic groups that were geographically located. And when it split apart, we had these massacres in Bosnia, horrible results. And so we've seen that getting different ethnic groups that are geographically situated to play in the same sandbox in a friendly way has been a real challenge, not just in the US, where it's more benign actually, but worldwide as well. So geographically based ethnic or religious groups are protected under federalism by allowing groups that are geographically located to maintain autonomy. And so you can be an ethnic or religious or racial minority within a nation state, but be a majority within your local area. And that allows, that's what I've called kind of the federalism deal, that allows local, uh, locally based groups to maintain political control within their sphere. And that's the upside, the positive. The negative is that when you have this more localized control, the risk is that a minority within that local area doesn't have the protection. And that was the story in Yugoslavia, doesn't have the protection of a national entity that preserves their civil rights. So I've argued that part of the federalism deal is that you need to have some form of protection, core protection for civil rights and human rights. And then you can have different tax rates, different priorities, and so forth. But there has to be a common ground of protection for civil rights that protects these minorities within these local areas. So I view federalism as a different way of protecting civil rights. It's a civil rights, a different paradigm, if you will, that is basically supporting decentralization. And there is an important dimension of autonomy and choice at local levels so that you can be a majority in Tennessee, but you don't have to persuade folks in New York or California to your way of thinking. And so that becomes an important way of mediating conflict. And it's very important. But in order for that to work, we've seen tremendous potential abuse. And Katie talked about this, where Madison described this as factions, where local majorities, if they're unconstrained, can actually oppress local minorities. So you need to have within the local system protections for those local minorities so that their basic rights are protected. And so that's what we've seen in the US. We've seen, and that's the bulk of what my story is going to be, is that what we've seen over time is an expansion of federal power to protect local religious, political, and racial minorities within states. And I'm going to describe the mechanism of that. I want to start with describing the constitutional structure, and then I'm going to talk about the expansion of federal power. The constitutional structure is really built upon and relies upon states. I talked about the United States of America. Well, the very fabric of our Constitution is constructed around states. The Congress, the Senate, is based upon representation, 2 senators per state. Many are critical of that, but that is the foundation of the Senate. It's a state-based representation to our national legislature. Even the House, which was supposed to be the people's house, is based upon state representation. It's population, but population filtered through the states. So that if Tennessee gets greater population, or Texas, which has been the big winner recently, gets more population, they get more representation in the Congress. So it's a population, critically, a population metric, but it's filtered through the states. And then third and finally, the other branch, the executive branch, the president, is elected not through direct popular vote. Many people don't recognize this, but we don't have a vote for president. When you vote, you're not voting for president. You're voting for an elector to the Electoral College who will then select the president. And so the Electoral College is a state-oriented or state-focused institution that elects our president. And it turns out that state legislatures have the authority to choose how the electors are selected. And for much of our history, the legislatures of many states chose the electors, and we didn't have popular election. Now every state chooses the electors, but they could change that. So if you're looking for a weakness or a strength, however you want to see it, the state legislature of Tennessee could decide we're not going to have an election. We're going to choose the electors who will, in fact, then choose the president. So it's an eye opener to many people that there's no requirement for states to have an election. That's a political choice that all states have made. And then how the state's electors are chosen is a matter for the state to determine. Now, all but 2 states have a winner-take-all system. So whoever wins the popular vote in the state gets that state's entire electoral votes. 2 states have an apportionment system, Nebraska and Maine, so that some of the loser statewide may get an electoral vote in a district, and that's happened in both Maine and Nebraska in recent times. The advantages, just to repeat and summarize, are there's pluralism, so that states, you can be a majority in a state and a minority in the nation and have some autonomy and political clout, and your political tastes can be accepted. So Tennessee is a low tax state. California is a high tax state. That is not, there's no requirement that there be a national uniformity to mediate that. California's taste for tax would not fly in Tennessee, and Tennessee's taste for tax would not fly in California. But that only works as long as a core of human rights and civil rights are protected. Okay, let me now turn to one of the important battles in the formation of our Constitution, and that was on the Bill of Rights. The original Constitution did not have a Bill of Rights. Katie mentioned that the original Constitution developed a source of authority for the federal government. The federal government does not have inherent authority, but it must find a source of authority. And the original framers thought that if they didn't give certain authorities to the federal government, then they wouldn't have it, and there was no need for a Bill of Rights. Those who were ratifying the Constitution concluded otherwise, and history has borne them out, that what we call absence of source of authority is not enough to protect specific rights. And the Bill of Rights protects specific rights like freedom of speech, free exercise of religion, and so forth. And the Bill of Rights was enacted to protect against overreaching by the federal government. But in a case in the 1830s called Barron against Baltimore, the Supreme Court held that the Bill of Rights only protected against overreaching by the federal government and did not apply to the states. And so, therefore, you went into the Civil War where your First Amendment rights might be protected by a state constitution, but not by the federal constitution. And so now what I want to turn my attention to is the expansion of federal authority in the name of protecting individual rights. And I want to focus on 3 things. First, the 14th Amendment, which was enacted after the Civil War. It gave protections to individuals against overreaching by the states. So that the Bill of Rights was incorporated slowly over 100 years, but slowly so that it applied against the states. So you have First Amendment rights now as a state citizen, even though you don't have that by the original Constitution itself. The Bill of Rights now protects individuals against state overreaching as well. The civil rights cases in the 1880s made it very clear, however, that this protection in the 14th Amendment only protected folks against action by the state. So that when I said you were protected in your First Amendment rights, only as against the states. And I remember a great conversation I had with the daughter of a friend of mine who was a journalist at the university school. And she said, don't I have First Amendment rights against the school? And I had to tell her that the answer was no, because the school was a private school. If she went to a public school, she would have First Amendment rights against the government. And she certainly did not have First Amendment rights against her parents, much to her chagrin, because they were not the government. Then the expansion, I want to talk about 2 expansions. One is the Commerce Clause. That has been the vehicle for expansion of federal power. And Katie mentioned this notion of dual federalism. Originally, you had two spheres, federal and state. Over time, in the New Deal period, that idea of dual federalism faded away, and the federal government got more power, power to regulate not just commerce itself, but where there's a substantial effect on commerce. And substantial effect could be accumulated. So if you're a farmer who produced a few bushels of wheat, the court would ask whether all farmers together had a substantial effect upon commerce. Very great expansion of federal power. The New Deal period also from 1938 to 1937, sorry, to 1942, in that 5-year period, said that the federal government could achieve social welfare goals, public policy, protecting against child labor, against unfair labor practices, and so forth. So there didn't have to be a link to commerce. The federal government could achieve important social welfare goals. That was very important in 1964 Civil Rights Act, where Congress was allowed to achieve the social goal of racial non-discrimination in public accommodations, even though most people said what was involved was the moral concern about equal rights for minorities. The way it was achieved, and the Kennedys developed the architecture for that, they were very pragmatic. They said, we don't really care what the theory is as long as we can get it done. And there's pretty good evidence that they were very pragmatic about that. And they said, we know that the federal government can legislate on morals under the Commerce Clause. And so the 64 Civil Rights Act is justified as a regulation of commerce, with the federal government establishing a rule against discrimination, even by private parties based on race. And the fact that there was a pretext for social welfare goals was not to defeat federal power. The last point here is the spending power. In the post-New Deal period, federal government expanded its power by spending money. And a great tool for expanding federal power was conditions on federal spending. And so if you wanted federal money for schools, you would have to abide by racial non-discrimination, or later sex non-discrimination. And we see that issue playing out now, is that expanded federal power in the name of expanding rights. Some would argue that the federal government can be limited and can go too far, and that's the criticism of the current administration. So there we have the expansion, Commerce Clause, spending power, and the 14th Amendment. So the last point I want to raise, and I will only do this quickly, is whether or not there are any limits built into the system, or whether the federal government has become not just a government of enumerated powers, but of plenary powers. And the answer is there are a few minor restraints. One is under the Commerce Clause. If the federal government wants to achieve a goal, it can do so, but it cannot force a state to act in a way that is protective. And in the that's called the anti-commandeering principle. And on the spending side, the federal government must give notice to the states of what their obligations are, and the feds cannot coerce. That was the theory behind the Affordable Care Act Medicaid expansion provision. So my concluding point is that, how does this work out today? Well, the states are resisting the federal government under the anti-commandeering principle, and they are not, and the states that are sanctuary states or sanctuary cities are refusing to participate in various immigration policies of the federal government. That's their right under the anti-commandeering principle, and they're pushing back against the federal government. The federal government is not without leverage. It can induce, or cynics would say bribe, the state governments. They can threaten to cut off funds, but the federal government cannot force the states to enforce federal immigration law. And there's a fine line between forcing states to participate and blocking federal authority. And that's the line. The states cannot block the implementation of federal power by federal agents, but it can refuse to participate. And so that's where we are. That's the fine line. And I thought I would conclude with that modern example of the sanctuary cities. They can be sanctuary cities because of this anti-commandeering principle. Thank you.
Thank you. We're going to open it up to questions. I don't see anyone with their hand raised or any questions yet in the chat, so I'm going to ask a question. When a state like Tennessee refuses to accept federal dollars, what's your, for instance, on Medicaid expansion, we'll say, what through the prism of states' rights versus federal power, do either of you have any comment on that? Does it give them carte blanche to do whatever they want, or it doesn't matter, or any thoughts?
Yes. Well, I'm sorry, Katie, do you want to go first on that, responding to that?
I defer to you, Professor Blumstein, on this one.
Well, actually, the Medicaid expansion, I'll take responsibility or credit depending on your political view, but I developed the theory that the Supreme Court ultimately used in allowing states to choose whether to expand. That's part of state autonomy that's left. And states can be induced. So 40 of the 50 states have expanded Medicaid, but they can do it by inducement. What the Supreme Court held in the NFIB case is that states could not be threatened with the loss of pre-existing Medicaid. They have to have a right to choose. And if they choose not to accept federal funds, that is a state right. And they cannot be forced to abide by conditions to that spending. And in the NFIB case, the federal government could not force the states to accept expansion at the risk of losing pre-existing Medicaid. So there are 10 states that have chosen not to do that. Interestingly, I advised the legislature on this, and I said, if you want to expand, get a commitment from the administration that if you want to opt out of Medicaid, you'll be allowed to do that. That never happened. And so the state didn't go in because they didn't get assurance that they could opt out without having to accept the full obligations of Medicaid. Remember, and I tell this to the students, the matching in Medicaid expansion is 90% federal dollars, 10% state dollars. And people say, wasn't that a deal you can't turn down? But I like to say I could get a 90% discount on the Hope Diamond. And guess what? My wife isn't going to get it. There are certain things that are very expensive, and 10% of a big number can be a very big number. And the same thing is true. The other example I like to use is, imagine Bill Gates would give you his house, which is about a $38 to $40 million house, a huge house. And he would say, I'll give it to you, but you have to pay the property tax and the maintenance costs. So it sounds like a great deal, but there's some great deals that are too expensive. And ultimately, Tennessee was not sure that it was willing to take on that obligation if it couldn't change its mind. And it never got assurance from the federal government that it could change its mind. And so that's why we don't have the expansion. I testified before the state Senate on that issue. I said, it's fine to expand, but be sure that you have an assurance that you can opt out again without having to give up all of Medicaid. Never got that assurance.
Debbie has a question.
Yeah. So my question is actually, Professor Blumstein, you talked about that federal government needs to provide sort of a level, a background of human rights and civil rights that to protect everyone, the states could then fit their issues into. And so I'm really be curious to hear from both of you all about what you think of as the future of the Voting Rights Act for now that it's 60 years old, what does its future look like?
Katie, do you want to try that one?
I mean, I think I'm going to defer to you again. It's a good question, and at this point in time in particular, I would say my opinion is not positive, but I'm hoping that Professor Blumstein might have a more optimistic view of the future.
Yeah. Well, that's another one. Voting is an area that I've been involved in. When I first moved to Tennessee, I brought a suit. Tennessee had a requirement that you live in the state for a year and 90 days in the county. And when I moved to Tennessee, I was not eligible to vote right away. And so, like a good young law professor, I filed a lawsuit, which ultimately went to the US Supreme Court. And that durational residency requirement was declared unconstitutional. That case probably enfranchised more people than any a single case before it, whereas since, as a matter of fact, the Voting Rights Act was very important legislation passed in 1965, and I don't see much threat to the core of the Voting Rights Act. I think there is a disagreement about interpretation of how one proves discrimination under the Voting Rights Act and whether what's called the pre-clearance requirement is still needed. That was very heavy medicine. The Supreme Court struck down the triggering mechanism in a case called the Shelby County case about 10 years ago. And so there's legitimate disagreement about that. There's a lot of hysteria that flows. I remember speaking at a program at Princeton, actually, what then was called the Woodrow Wilson School, about the Voting Rights Act. And some advocates thought that imposing a requirement of proving discrimination was the end of the Voting Rights Act. And they actually succeeded in amending the Voting Rights Act in 1982 so that there's no need to prove intent to discriminate. You can establish that by certain outcomes. But what that really means, even 40 years later, is still unclear. And I published an article just this past Christmas time about the Voting Rights Act and how they've overlooked a case and so forth. So I think one has to look at the issue in a case-by-case basis. There's a lot of rhetoric there that goes on, much too much for my taste. It really depends upon what provision one is talking about and whether, as long as the rights are protected, which they are, how you prove that and what that really means and what the theory is still up for debate. And that's very much part of the conversation. I'll be glad to go into more detail if you want, but I think the Voting Rights Act is safe, but certain aspects of it are subject to dispute or debate right now. And I think there's a case now pending out of Louisiana that's going to deal with that question, where whether there is a claim of vote dilution that's freestanding, or whether the claim of vote dilution really only comes with a deficiency in the process, where there's some race discrimination in the process. And I think the argument that I make is that the Voting Rights Act is a process-focused law that basically goes to the question whether minorities are fenced out of the political process. And if they are, then they can bring an action, not to assure any kind of racially based proportional representation. I think that position will eventually prevail.
Thank you. We have a question in the chat. Where does the opposition to eliminate the Electoral College stand currently? I hear there's a movement to do so. As always, there's always one to do so, but then it dies down. So just sort of I suppose, a dipstick perspective on eliminating the Electoral College. Do you both care to comment on that? That's just an opinion, I think. Katie?
This is an interesting question because I have to go back to James Madison and, in setting up this system of government, even though there was a real desire to have greater representation for people. Madison and others, but Madison is one of these framers who's really concerned about giving people, full autonomy to vote, to cast their own vote, versus having this kind of check through the Electoral College. So again, from a historical perspective, I think when you put it into context and think about why the framers made these decisions, perhaps they saw the value in it at the time, but it's kind of, you have to ask the question of, has our system, or at least the way it was structured, have we evolved past that? And I think a lot of Americans feel like they are not heard. At least I hear this a lot in the work that I do with the public is, why would I participate when my vote doesn't matter? And I think the Electoral College plays a big part in that.
Yeah, as a practical matter, I think the questioner asked pragmatically what's going to happen. I think the Electoral College, there will not be amendment to change it. Some states have developed a creative approach where they all agree to vote in a certain way, so that they can, in a sense, bypass the Electoral College, that they would change their votes in a certain way. That's gotten some adherence, but not enough to change. And some states are changing their mind about that already. And I think there's a question under the Compacts Clause, whether that type of state agreement needs congressional approval or not, which would not happen. So I wouldn't hold my breath right now. There's a lot of talk among my con law colleagues who don't like it. I happen to be one of the academics who actually agrees with the Electoral College, and I'll be glad to talk to you about that. But I think that assures that big states don't swallow up small states. And if states want to achieve more deviation, if you will, or pluralism, they're free totally to allocate their Electoral College votes by congressional district, for example, which happened a lot in the 19th century. And so if one is worried about the concern that Katie had about anomie in a given state, you can give residents of, say, an urban area an electoral vote that they might not have on a statewide basis. I think that states control that. States can do that. You don't need a constitutional amendment to make that change.
Thank you. Vandy, you have a question.
I do. Haiti, I've got a question for you, and I want to take you back to the 18th and early 19th century with Jay Manson. And I'm just concerned or curious, given your knowledge of his writings and his work, and given the milieu of that period in time, what do you think his position would have been on sending federal troops into a sovereign state without invitation?
There you go.
That's a great question.
Somebody had to ask it tonight.
I mean, again, he is very concerned about, I mean, he's one of the strongest proponents of having this balance of power, separation of power in the Constitution, because of this fear of tyranny and acting without going through these, what we might think of as tedious federal processes. He wrote also about, passions being checked by reason. And that's why we have these different checks and balances, so that one branch cannot act, out of passion, and that these things need to go through the process and be checked by these other branches. I will say, I can't speak to what he would say, but I think he's rolling over in his grave right now. There's some disturbed earth in the Madison Cemetery at Montpelier. So, yes, I think he would find this time very, very disturbing.
Thank you.
Curtis has a question.
Yeah, I hope you all can hear me.
We
My
can.
question concerns gerrymandering. Clearly, the Constitution sets and allows the states to set the rules for geographic representation in terms of elections. However, that's led to considerable distortion that has obviously, in my opinion, distorted things to a point that it needs remedy. My question is there some federal remedy that can be applied that perhaps the Supreme Court, maybe not this current one, but prior ones would have found acceptable?
But let me try my hand at responding to that. The problem with gerrymandering is that no one has a good definition. There are some academics who have talked about this, and the Supreme Court has actually held in the Rucho case that there are no good standards that have a consensus, and therefore there is no Supreme Court ruling on political gerrymandering. Now, racial gerrymandering is an easier case if you can show that race is the predominant factor in bringing about a particular apportionment. That's actionable and it can be brought, but it's on a ground of race discrimination. And Tennessee actually had a case with the Jim Cooper situation where Jim was politically gerrymandered. The case was brought and it was dismissed because political gerrymandering does not lead. It's hard to define, and it didn't lead to a judicial remedy. Then they said, well, maybe there was a racial gerrymander, but they gave up the case. They couldn't prove that. There was no evidence that it was a racial gerrymander. It was a political. It was a Republicans basically gerrymandered and put him out of office. And so the dissenters, Justice Kagan, thought that some scholars had developed an approach to gerrymandering that had some intellectual coherence. But when the court looked at that, the court concluded there was no there. And I'm actually skeptical that if you look at different rules, what are the rules? Does each district have to, or does the state have to reflect the voting by party? Well, that could be hard. Do you want it? For a long while, when there was concern about giving blacks adequate representation, there was a rule of thumb that blacks didn't vote as often as whites. Now that's changed, but in the bad old days of Jim Crow, there was evidence that blacks didn't vote as much. So there were more blacks put into a district to assure that blacks would have representation. Is that gerrymandering or not gerrymandering? Or is that to assure what the advocates thought was a good outcome? So it's fraught with questions about what that really means. And it's become a bumper sticker rather, in my view, rather than an analytically coherent position. So I think that I wouldn't hold my breath at this point. The case is recent. It's 2019. The Rucho case was 6 years ago. The court had flirted with this issue for many years, but they only had 4 votes to declare that not what's called non-justiciable, outside the scope of judicial review. And in 2019, they got the 5th vote. And I don't see that changing. It may be that if there's more different justices, they'll go back to that, but it's not clear what would be put in its place. So it could happen. I don't want to never say never, but I'm skeptical that that's going to happen anytime soon, because there's not a good answer for defining what it is, as opposed to racial gerrymandering, where there's a pretty good body of law. And that's the issue, by the way, in the Louisiana case, whether it involves racial gerrymandering or political gerrymandering.
We are at our 9 o'clock time, but I did want to ask one more question, if I may. We're seeing a rise in executive power, possibly emanating, putting in the unitary executive theory into practice. Do you see that as an increase in federal power or something else completely?
That's a separate, I'm sorry, is that aimed at me?
I think so.
Okay. It's a separation of powers question. It's
Mhm.
not a federalism question so much.
So you don't think that the rise in executive power is actually a rise of federal power?
I think the theory always is the federal government has the authority. It's a question of the degree of congressional control or not. So I think the unitary executive is a theory that suggests that we have three branches of government, and the executive branch is controlled by the president. And the president, there was a time in the 30s and 40s where the thought was we needed to get politics out of politics. And then that developed this era of expertise and these agencies, and they don't fit well within the three branches of government. They're a fourth branch. And the criticism that has emerged is that most of the important issues are not issues of expertise, but they're issues of value judgments. How much pollution are we willing to accept? How, what should be the right speed limit? There's not an expertise answer to that. That really involves political choices. And so when you delegate all this authority to these agencies, you're taking away political accountability. And I see a movement towards greater accountability. I think this term, the Supreme Court may curtail the power of federal agencies and increase the power of the federal government. Whether it'll go towards the Scalia view with the unitary executive, I'm skeptical it'll go that far, but I think there will be inroads that allow for more accountability so that you know whom to blame. Now it's no clear, if you don't like sending troops into Los Angeles, you know whom to blame and whom to vote against. There's no doubt about that. If this is done by an agency, there's a problem. And people who don't like it, that's fine. That's our political system. If you don't like it, you have to know whom to be against. And there's no question whom to be against if you don't like that. That's pretty clear. And so we'll see if that withstands the midterms or next election. But that's what the unitary executive theory is designed to do, to allow the president to have control and to know whom to point the political finger at if you don't like the policy that's involved. And we're seeing that play out. There's no doubt it's not some bureaucrat who's sending troops in, it's the president. And people are mad at him, or some are very favorable to him, depending upon your political perspective. But there's no doubt who's responsible and whom to be mad at. And that's what the unitary executive really emphasizes.
All right.
Political accountability.
I want to thank and I ask everyone else to thank our wonderful guest this evening. This has been an enlightening and always inspiring session. I thank you both. And again, this recording will be available on our social media places. And with that, I bid you all a good evening.
Thanks to the audience for participating.
Yes, thank you.
Good night.